So once you've embarked on this journey, what do you need to know? The first thing you should know, you look to Stanley and you say the Constitution does not permit the state to presume rather than prove a parent's unfitness, solely because it's more convenient to presume than to prove. So what's happening with most of you is you're going in, you have these, what they call hearings, and they turn around and use low standards of proof and decide, sometimes it's just attorneys in the room, the parents don't even get to go in, and the judge decides one of you gets their rights deprived. One of you doesn't get to see the children as much. One of you gets to pay for the majority of this, right? Well, a lot of that is because you didn't have an attorney or yourself argue that that's not permitted. And this case in Ree Sanders that we're going to look over in a minute says exactly that. It may be a Michigan Supreme Court case, but you guys can take the wording right out of it. You can tell your judge, look, these are Supreme Court justices from another state. I understand it's not controlling. But this is not just argument made by them. They took a lot of the argument from the Supreme Court of the United States. And like I said, we've written these arguments in our books, and now you know they work. And they're talking about fundamental things, not things that just all of a sudden were given to us. These are not new rights. So you can ask your judge to consider using them. And if that judge doesn't, use the same procedure that this father in this case did. He used an interlocutory argument. He actually challenged based on before his case was final, which is super, super important because a lot of you are getting stuck in the process. I don't know if this particular parent's here, but one of them is they keep having what they call status hearings or status conferences. And all they do in those is decide what's in the best interest of the child, right? And the parent keeps trying to argue, I decide best interest. What happened is the state cut that step out. They cut the step out where they were supposed to prove the fitness of the parent before they started deciding best interest for the child. So because they cut that step out, that parent now needs to go to the appellate court and argue that that step was skipped and look at, the rest of the rules in their state and put together a solid argument to challenge that court's using jurisdiction over them without the proper due process. And you'll understand it more, again, if you read in Ree Sanders. So all of these things that they order in these hearings that most of you are going through, psych evals, family studies, restrictions on your time with your child based on waiting for the results of the psych evals and the family studies and social studies, anything else, based on a facilitator's decision. So they are not using proper due process. But here's the other issue. If you don't demand a fitness hearing, then they can get away with this. Because there's other people that tried to challenge this very same thing that this father did in Michigan, and they didn't get hurt. Do you know why they didn't get hurt? Well, this court says why. And in fact, I'm going to go to that case real quick because I want to show you guys.
And when you're demanding a fitness hearing, you're not actually demanding a hearing. You're demanding that they not take any action to deprive you of any of your fundamental rights without first holding a hearing. Don't take that to mean you should demand and schedule a hearing. Force it upon them. It's their job to take the effort to prove you unfit. And what you need to say is, you cannot deprive me of fundamental rights without first proving me unfit.
Right. So first of all, recognize that if you're getting stuck in status hearings, status conferences, judge keeps saying, I want to wait for the next study, I want to wait because they just made another claim, then you need to push for that adjudication hearing.
So the deal is, when they make these temporary orders, their clock is ticking, and they have to prove you unfit within a certain amount of time, or they have to return your child to you. And that's what you need to put before them. Due process demands that if you believe there is probable cause to think that I'm harming my child or that I'm unfit, that you prove that in a reasonable amount of time. And if you fail to prove it, you must return my child to me.
Okay, and here's let me go back real quick because I said, why did Mays, it's a case called In Re